over custody of the Constitution, the central issue being whether Parliament's power of amendment was complete and unrestrained. In the initial decade of the Indian independence, of the nation's independence, a stronger central government with far-reaching powers had assumed importance in order to drive socio-political revolution. The birth of the nation was into what Granville Austin has described an emergency. Two decisions immediately fueled a change in the Constitution. The decision of the Supreme Court in Ramesh Thapar versus State of Madras, striking down the Madras Maintenance of Public Order Act, 1949, and Brij Bhushan versus State of Delhi, striking down the East Punjab Public Safety Act, immediately prompted the need to insert the word reasonable in Article 19(2), as well as new grounds of public order, friendly relations with foreign states, and incitement to an offense in order to allow the state to regulate free speech. One other article into the Constitution reflected the centre's concern to centralize power through the Constitution and enact property legislation. By the First Amendment, Article 31A and 31B were also added to the Constitution, which expressly saved laws providing for the acquisition of estates from being void on the ground that they are inconsistent with fundamental rights. Acts and regulations specified in the 9th Schedule would be immune from the operation of Article 13. In keeping with the tense atmosphere into which India was born, the operation of the Preventive Detention Law brought into focus a jurisprudential position by the Supreme Court which was deferential to the state. This was clearest in A.K. Gopalan versus State of Madras, where the majority held that Article 22, being a complete code relating to the Preventive Detention Law, the validity of an order of detention must be determined strictly according to the terms and within the four corners of Article 22, and that its validity cannot be tested against Article 19 and 21. In other words, the fact that the fundamental rights were not a continuous stretch of entitlements, but isolated pockets of discrete rights was the jurisprudence of our court, or the Supreme Court at that time. So the working of the Constitution in the first decade of its existence, in the context of a newly born nation looking to consolidate national unity, was characterized by deference to the state agenda. But to the exigencies of time, the Constitution adapted and endured. A developing body of comparative constitutional studies studying the resilience of constitutions has indicated that there are three features that exert an overwhelming bearing on their endurance. The first is inclusiveness of the Constitution. The second is its specificity. And the third, its flexibility. Our Constitution serves as an outstanding example of durability, in no small part due to the formal power of constitutional amendment granted to Parliament in Article 368. The power of amendment is the foremost expression of flexibility and has been exercised to reflect the march of time and the evolving needs and values of society. It indicates, above all else, the ability of the Constitution to adapt to changing circumstances. Since the enactment of the Constitution in 1950, Article 368 has been used extensively. As of October 2018, there have been more than 100 amendments to the Constitution, with amendments both frequent and wide-ranging. However, the flexibility of our Constitution is balanced by the need to protect the Constitution's character as a supreme law, insulated from the whims of the government of the day. This was achieved by virtue of the basic structure doctrine in Keshwanand and the jurisprudence of the Supreme Court that followed, which placed limits on the plenary amending power of Parliament, thus safeguarding principles that form the bedrock of our constitutional order. As a result, the procedure for amendment today is reflective of a finely struck balance. It is neither too rigid nor too flexible, blending pragmatism and adaptability with carefully designed safeguards. Indian constitutional history has borne witness to a number of landmark constitutional amendments. What was formerly the fundamental right to property enjoys the unique distinction of being the most amended provision in our Constitution. Protected as a fundamental right until the passage of the 44th Amendment in 1978, the right to property was thereafter deprived of its fundamental status to reflect the growing realities of a conflict between the protection of existing property rights and the desire to move towards a more egalitarian society, which would involve a redistribution of land. The 61st Constitutional Amendment of 1989, passed in recognition of political consciousness of the country's youth and the desire to integrate them into the political process, reduced the voting age from 21 to 18 for elections to the Lok Sabha and to the state legislative assemblies. The 73rd and 74th Amendments, which brought through the insertion of Part 9 a major boost to the protection and recognition of local self-governing models in India by providing a constitutional status to panchayats, namely the rural self-government, and municipalities, urban self-government. The 86th Amendment of 2002 recognized the primacy of education for the nation's youth, and through the insertion of Article 21A, made free and compulsory education between the ages of 6 and 14 a fundamental right and responsibility of the state. So we would miss the essence of the Constitution if we do not remember to dwell upon the institutions which the Constitution has created. Democracy thrives when institutions thrive, and democracies fail, nations fail, when institutions fail. So the resilience of our Constitution lies not merely in placing the individual at the forefront of its endeavors, but in terms of creating vibrant institutions. And these are institutions which really sustain our democratic structure. The makers of our Constitution were confronted with various tensions, which ultimately shaped the character of the Constitution. The Constitution of India is a text that governs over 1.2 billion people in 29 states, speaking 22 constitutionally recognized languages, not to mention hundreds of dialects, and practicing virtually every mainstream religion in the world. Indian constitutionalism has been described as a boisterous and contentious enterprise that strives to endow the largest, most diverse and complex democracy with legal form. The sheer diversity of the persons it governs throws up challenges in the nature of religious, cultural, and linguistic differences. Significantly, this diversity has led to contradictions in the Constitution. These contradictions were often in the form of a grant of a different status to a community, identity, or territorial region to preserve the plural social fabric of our nation. Rivaling the importance of a social revolution to be fostered by a transformative constitution were the goals of national unity and stability, considered as prerequisites for a social renaissance. The framing and working of the Constitution can be described as an attempt to balance the contradictions of a multicultural and multi-ethnic society, which, among other things, involves reconciling a secular state with a fundamentally religious society. Though the word secular state was introduced in the Constitution only in 1976, the secular nature of the Indian state was affirmed by the Constituent Assembly. During the framing of the Indian Constitution, a significant question arose as to whether religious and other groups should have separate and distinct political representation in electoral processes. While the Government of India Act contained provisions for communal representation in electorates, the policy of communal representation was rejected by the Minorities Subcommittee and the Advisory Committee. Finally, communal representation was done away with by Article 325 of our Constitution. The draft of the Constitution was a declaration of social intent. While rejecting political fragmentation on the basis of religion, the Assembly granted autonomy to religious minorities. The Charter of Fundamental Rights, based on the principle of non-discrimination, begins with Article 15 telling us that it applies to discrimination on the grounds of religion, race, caste, sex, or place of birth. The freedom of religion located within the Charter is expressed in 4 articles, 25 to 28. The centrality of secularism in the constitutional system was reinforced by the Supreme Court by assigning it in the decision in S.R. Bommai the value of a basic feature of the Constitution. Our Constitution contains a panoply of instruments for the protection of minorities based on an innovative combination of individual and group rights. The Constitution does not limit minority rights to the recognition and protection of their culture alone, but it also recognizes the right to establish and administer educational institutions of their choice as a corollary of their fundamental freedom. Finally, Articles 350A and B reinforce this right, but with an ambit limited to linguistic minorities, providing that it shall be the endeavor of every state and of every local authority to provide adequate facilities for instruction in the mother tongue at the primary stage. Our Constitution is a multicultural document which provides political and institutional measures for the recognition and accommodation of the country's diversity. In India, cultural and religious minorities are not considered as external elements, but as actors participating in the construction of a common plural identity and as basic elements in the constitutional system. Cultural heterogeneity celebrates precisely those plural values which would seem to contradict the unity required for successful democratic constitutionalism. Another constitutional contradiction which has been addressed is asymmetric federalism. If you see the working of the Constitution right through to the 1970s, you're impressed by the sense of the centralization of power with the center. That has given way post-1990 to a decentralization of power as regional political parties have grown and the aspirations of states have been noticed by the Supreme Court. Similarly, our Constitution recognizes diversity when it provides for special measures for governance in areas inhabited by indigenous communities or the scheduled tribes under the 5th and 6th schedule of the Constitution. These constitutional balances reconcile social, political, and cultural differences. The Constitution embraced these differences. In doing so, it has fostered a heterogeneous cultural and social fabric which recognizes different identities. The multicultural identity of our country is an ode to its strong democratic values which do not compel homogeneity. Homogeneity is an anathema to our Constitution. This brings me to the topic of constitutional identity. Constitutional identity encompasses concepts as broad as the features and provisions of the document itself, to the relation between the Constitution and the culture in which it operates, and to the relationship between the identity of the Constitution and other relevant identities, such as national, religious, or gender identities. In his seminal book called Constitutional Identity, Gary Jacobson argues that a constitution acquires an identity through experience, from a combination of the aspirations and commitments that express a nation's past and the desire to transcend that past. He acknowledges the complexity of constitutional identity by stating that just like identity is not fixed in the distinctive makeup of the infant who first emerges from the womb, the identity of a constitution is only imperfectly knowable through the provisions promulgated at the time of its adoption. Yet it is the most obvious starting point for commencing an examination of constitutional identity, and the first step on the long and winding road from political design for collective identity to a socially embedded institution that actually fosters such identity. Modalities of legal subjectivity, identity, and citizenship are rapidly shifting in the context of contemporary globalization. While state nationalism remains a strong force, be it in Trump's America or Erdogan's Turkey, there are concurrently many other modes of connection that are shaping people's sense of personal and collective identities. A range of new legal relations are brought about by new labor markets, new industries and commodities, new forms of secular and religious violence, new cultural and sexual politics, new reproductive technologies, new materialistic understandings of agency, and a rethinking of the autonomous subject citizen, with increasing attention being given to a blurring of conventional divides between the human and the non-human. Emerging changes in science and technology pose a challenge to our legal and constitutional values by disrupting conceptions of the very definition of our personhood and of our identity. The burgeoning of multifaceted and intersectional identities, accompanied by an acknowledgement of the inherent fluidity of our identities, lends immediacy to the need that our Constitution must keep pace with them. Increasingly so, our Constitution is recognizing the diverse identities of our citizens. An important example is the recognition of different gender and sexual identities. While the break from a heteronormative sexual framework has been gradual, courts have played an important role in recognizing the autonomy of individuals within the Constitution to determine their orientation as well as their gender identity. It was my belief, while writing the Section 377 judgment, that we the people of India, in our preamble, must be an ever-inclusive and expansive we. The we in the we the people of India is not prefixed by only, stating only we or any other such prefix connoting religious, caste, class, sex, or political ideology or ideological affiliation. It is a simple and obvious interpretation. But as George Orwell said, the work of intelligent people is to restate the obvious, because the devil is very often in the detail. As people in the field of law, we would agree that the limits of our words are the limits of our world. The shift in our jurisprudence from R.C. Cooper, the bank nationalization case, and from A.K. Gopalan, which held that Part 3 does not seek to enunciate distinct rights, but weaves a pattern of guarantees in a single thread, has been crucial. Weaving constitutional rights as overlapping has opened new avenues to the Supreme Court to realize the emancipatory power of the Constitution. This issue presented itself before us in the Sabrimala temple entry case. Article 25 protects the equal entitlement of all persons to a freedom of conscience and to freely profess, protect, and propagate religion. Article 25 says it is subject to the other provisions of this part. Article 26 does not embody this additional stipulation found in Article 25(1), which subject it to the other provisions of Part 3. But does that by itself lend credence to the theory that the right of a religious denomination to manage its affairs is a standalone right, uncontrolled or unaffected by the other fundamental freedoms? It is the shift in our jurisprudence that grounds Article 26 not as an independent silo, but among a large cluster of freedoms which the Constitution has envisaged as intrinsic to human liberty and dignity. Hence, the dignity of women, which emanates from Article 15 and is a reflection of Article 21, cannot be disassociated from the exercise of religious freedom under Article 26. A conversation within the Constitution between religion, dignity, and morality is aided by such a shift. Our Constitution, above all, is a transformative document. It was to usher in a radical transformation from a colonial regime to a liberal constitutional democracy. It sought to empower the individual who it placed at the very heart of society and polity. The promise of substantive equality in Parts 3 and 4 was truly revolutionary, for it gave many the language to articulate, voice, and agitate moral indignations. Citizen interpretive practices remain diverse, conflicted, and contradictory. These articulations are a litmus that test the successful functioning of the Constitution. At the heart of the learnings and unlearnings of the Constitution is its basic unit, the individual. We must not lose sight of the fact that the judiciary comes from the citizenry. The text of our Constitution, while the obvious starting point for interpreting it, was not intended to be the end of the interpretive exercise. The subjects of the Constitution, the citizens of our nation, have assumed new and diverse social and political identities since its inception. And the text of the Constitution has embraced these identities. The text is infused with meaning every time the court is called upon to interpret the Constitution. So when the court does take action upon this task, the question is, should it ignore the underlying values of our Constitution?